And welcome back into Open Line. I'm Chuck Long here with attorney Kevin Kennedy from the Kennedy Law Firm right here in Tennessee, Middle Tennessee. So glad that Kevin's with us this evening getting that legal advice, and this is the man to get it from, Kevin Kennedy. Kevin, I tell you, our line's so busy, so many people, like I said, they find that question that they have that they think is just for themselves, and they find that it actually helps a lot of folks when they ask it. So this is one of the best things that people can do.
Yes, we love it. So I know we've got a lot on the line, so let's hit them, get what we can get done there, Chuck.
All right, let's go to it.
Thank you so much.
All right, here we go. William, you're on the line with us. We appreciate you calling in this evening. Do you have a question or a comment for Kevin?
I've got a question.
All right, go ahead.
Well, I've got a question about a will, the executive and the power of attorney. She's not responsible. My mom passed and has the will. The will states that it's supposed to be evenly divided among three of us. It's already cashed in a CD. There's a RA involved with it. And she did a quick claim deed just a few days or a week before my mom passed away. And she did the same on the car and truck. And we cannot afford a lawyer right now, and we're just trying to see what our options are.
Okay, one of the things that we would address, first off, if an executor is not doing what they're supposed to, they're taking on civil liability. They are in a role that's what's known as a fiduciary role. They're in a position of trust, and they can be held financially accountable for that estate. If they were signing things they shouldn't, if they're disposing of, has the estate filed, and if they weren't, and if it's actually in the court, you could go in and ask the court to make a new executor because you have reason to believe that this one is not fulfilling their duties as a fiduciary. So, you know, a lot of times lots of lawyers don't charge anything for a free initial consultation. I encourage you to look and talk to them. Legal Services of Middle Tennessee, they help lots and lots of people. So look up, do a little research, and answer those questions. If you wait, it's laches kicks in. You cannot sit on your rights. If you know they're doing all this, you're going to have to act.
All right. Thank you so much. We appreciate you calling in, William. Right back to the lines right now. So we are going to Rochelle. Rochelle, we're glad that you're joining us this evening. Do you have a question or a comment for Kevin? Right, go ahead.
Okay.
Just a general question as far as discrimination suit. What type of documented proof would be needed, for instance, in an age case or race discrimination?
Okay, great question. Everyone understands they have a sense of justice in right and wrong. What's right, what's wrong? Obviously, the circumstances would dictate those levels of grievances. So how do you prove it? If someone overheard we've got to get rid of that old guy. He cannot keep up. He hurts the image. Well, someone can just sit down and say, well, I heard so-and-so say this and document it. You know, in the state of Tennessee, people have telephones that can have audio recording, video recording, and those kinds of things can be used. Also, you know, the truth is, pattern, it will display itself somewhere. And you'll hear people in their conversation, go clean the bottom of this railing. Well, you know, they didn't ask the 20-year-olds to go do the bottom of the 77-year-old to do, because they're setting you up for failure. And we know that's not right. And we know that's not fair. So again, when you see these complaints for discrimination, age or race, there's usually multiple allegations. And then if there's someone who overheard it, you can take them to the lawyer, let them fill out an affidavit. Why do you have people fill out an affidavit? Because sometimes their memory gets foggy and they can't remember the specific. Sometimes they get intimidated. They're scared. Well, I don't want to say that. I'm in trouble. Well, you've got that evidence already preserved, and your lawyer can take it to their lawyer and probably work out some kind of understanding. And when you do that, it makes the workplace better for everyone. No one wants to work in a hostile environment. And most employers say, we're going to correct it. We're not dealing with that because they don't want the liability. Thank you, Rochelle, for the question.
All right. Once again, great advice, and we do appreciate, Rochelle, you calling in this evening. See, if you do have one of those legal questions you've been thinking about, you've been pondering, just get on the line with us. The line is right there on your screen, 737, as we go right back to the lines. And Mike is on the line with us. We're glad that you called in this evening. Mike, do you have a question?
Yes. I guess I done the wrong thing. I went to juvenile court. My son's mother took me to court when he was 18. Come to show that I've had custody since '09, and they said juvenile court doesn't go back but 5 years. And somehow or another said I owe $10,000, which I showed all my receipts and all where I paid child support. Between me and her with, receipts and money orders. And the juvenile court turned around and awarded her $10,000, but yet I had custody of him since '09. So every time they got my stimulus money, my income tax or lottery winnings or anything like that, any kind of money that I get, she will get it. But I don't see how, the stimulus money is not a income tax. And, basically, I got railroaded because, I've had custody of my son since '09. And I should have had a lawyer when I went to court. But
Right. I think the greatest.
How can I go back to court to get this, turned back around where right now it is not right?
Here's a few things that we can consider. I love for you to bring those. So just bring options. The lesson to take away: don't go to court without a lawyer. I'm a very skilled lawyer. Been doing it for years. But if I were in that situation, I would get a lawyer and go. I know many people say, well, I can't afford this. I didn't have the money for that. You really can't afford not to have one because here you are with a $10,000 problem. So if you go to court, you should have all those checks. And here's a good thing. Many people get their girlfriends or their children's mother or their ex, they give them cash. If you don't have a receipt, you know what the judges say? If you can't prove it, it wasn't there. They want to see hard evidence. Well, that's not fair, but that's the way that they have interpreted the law. So again, if you got a bad ruling, what do? In that time frame. And so that's usually 30 days. And if in this circumstance, if she lied to the court, if she misrepresented to the court, and you have newly discovered evidence, then you can go see a lawyer, a petition, and say there was a fraud on the court. There's been a misrepresentation, and let me show you why this should be revisited. So there's all kinds of options and issues. You just got to get to a lawyer, and you got to be prepared. But the greatest lesson that you've shared with us today for these people, son's in trouble, I've told him he's got to get himself out of trouble. Parents, listen to me. Listen to the lawyer. They're not mature enough to handle it. That's why they're in trouble, and it's going to get worse. So again, you need to step in and stop. Thank you so much for your question.
All right. Thank you, Kevin. And like you said, don't go to court without a lawyer. So that's one of the things,
Not
again.
going to do it.
Absolutely. So we appreciate that call, Mike. All right. Right back to the lines right now. John is on the line with us. John, good evening. Do you have a question for Kevin? Can you hear us, John?
Yes, I'm here, buddy.
All right. Well, you're up, Kevin.
Yes, I do. This is a very easy. I want to say, Mr. Kenny, man, I wish he was on every week. Trust me. My question is, how do I get my name off a co-sign agreement? That's all.
Hello, come in. Do you know how many phone calls I get a week where people have that same question? Here's a word to the wise. Don't co-sign unless you're prepared to sign and pay for that. You know, the Bible says you'll be a servant to the borrower. You know, one of the problems that we get into, the bank money to those people because they find them not credit worthy. So they put pressure and say, hey, I'll sign for my children. hey, everybody is involved. You got family members that are begging, but when you sign it, the lending institutions pretty much have you. A lot of times there may be some options that you could hire a lawyer and then try to negotiate yourself out of that. Sometimes they would work with you if the payments weren't made. They repossess a car, let's say, for instance, and then you might buy that car after it's been repossessed. But if you don't protect your credit, it's going to be on your credit and it'll give you negative effects for a long time. So there's several options. I'd like for you to talk to a lawyer. One would be where you could try to write them and negotiate to see if you could get your name off. And it gets down to, is the car, or are you a co-buyer or a co-owner? That makes a difference. It could be Chuck and Kevin, or it could be Chuck or Kevin. Well, Chuck could sign that title. And if it's a really problem, you could just try to go buy the car, get it off, and go pay that debt. Or if it's only $500, we'll sell the car and pay a $500 defense, and we're not getting back in financial help and lawyer advice on that immediately. It won't go away, and it won't get better unless you take a proactive approach.
And John, again, Kevin, great advice. And like you said, don't co-sign unless you want to be responsible for that. So it's kind of the bottom line.
Hello, come in. Chuck, you ought to be a lawyer.
Well,
my greatest student right there.
Every time that you're on, so I learn a lot. All right, we've got a lot of you online with us. We know you have a lot of questions. If you are just tuning in, you are on Open Line, and we are talking to one of the best attorneys in the state. If you have a question, get online, 737-7587. We'll take a short break. Back with more Open Line right after this.